discussing the legal system, here I will briefly explain what the Dutch is. Dutch, a country located in northwestern Europe, is also known as Holland. Netherlands means lowland country. The name Holland from Houtland is a small country in Western Europe. With a rich cultural tradition, excellent higher education, and an open-minded and innovative society. The Netherlands is a parliamentary constitutional monarchy. The Netherlands is a very beautiful country that is famous for many things such as historic windmills, picturesque canal towns, and seemingly endless fields of colorful tulips. The Dutch is certainly one of the most densely populated countries in the world. The Dutch is a maritime nation that has history of growing and developing in the lowland areas of river deltas that empty into the North Sea in the northwestern part of the European continent. The history of the Dutch begins with a period of 4 centuries when this area was a militarized border of the Roman Empire. This border area was increasingly being pushed by the invasion of Germanic tribes who were moving westward. This country has a civil law legal system. The civil law system is a legal system that developed in Europe. This system emphasized the use of written legal rules in its legal system. Because it began its development in Eastern Europe, it is known as the continental European system. The main principle that underlies the continental European legal system is that law obtains binding force because it is manifest. In the continental European system, judges do not have the freedom to create law that have binding force on society, and may only interpret existing regulation based on inherent authority. The judge's decision in a case is only binding on the parties to the case. The main characteristic of civil law is the codification of law. The law in this system is arranged in the form of a systematic and written code, such as the civil code, criminal code, and commercial code. This codification aims to provide clear and structured legal guidelines for society and law enforcement. In civil law, the role of the judge is to apply the law according to the existing text. Judges do not create law, but interpret and apply existing laws. Roman Dutch law is the basis for the legal system of 7 African countries, as well as Guyana, Indonesia, and Sri Lanka. It originated in the Dutch province and was extended throughout the Netherlands and institutionalized in a number of sub-Saharan African countries during the Dutch colonial period. Roman Dutch law, legal system resulting from the merging of the early modern Dutch law, mainly of German origin, and Roman law, or civil law. Roman law spread widely throughout the territories once controlled by the Roman Empire, including areas that later become part of the Netherlands. Adatrecht, or referred to as customary law, which is a law whose validity is intense for the Bumiputra group, or what is certainly referred to as Native Indonesian and the East Asian group, during the Dutch East Indies colonial period. Since then, customary law has become an object of positive law study. The era before the VOC came to the archipelago. This era or period was marked by the position of customary law as positive law, which applies as real law and is regulated by the people in various kingdoms that live and develop on several islands between the Pacific Ocean and the Indian Ocean. French civil law, a type of codified civil law used in France and serving as the basis for or incorporating other legal systems in some 50 countries in North Africa, the Near East, and French territories and dependencies. Napoleon Bonaparte introduced what is now called the Napoleonic Code or Civil Code in the early 1800. Many of these major reforms, with extensive amendments, remain part of the current legal structure of France. French law distinguishes between public law, which deal with government, the French Constitution, public administration, and criminal law, and private law, which covers matters between private citizen or corporation. The Napoleonic Civil Code, a type of civil law, is referred to as the Civil Code or Code Civil des French, which is part of the French legal system and underlies the legal system of Bolivia, Egypt, Lebanon, Poland, and the U.S. state of Louisiana. This legal system combines the Teutonic civil law tradition of the northern province of France with the Roman legal tradition of the southern and eastern regions. The civil codes bear similarities to the Roman civil code. It deals with personal status, property and the acquisition of property with later addition, including civil procedure, commercial law, criminal law, and procedure and criminal law. Constitutional law or constitutional laws deals with the constitution and structure of the Netherlands. Constitutional law involves the powers of democratic institution, the holding of election, and the division of powers between central and regional government. As is the case in many civil law jurisdictions, in contrast to the practice in countries such as the United States, the practice of Dutch constitutional law is that judges are not allowed to determine the constitutionality of laws made by legislator, the government and parliament when working together. International law, or law of nation, involves the application of international law, especially those incorporated into treaties or agreements. In the Netherlands, the Dutch constitution contains an article that allows for the direct application of most international law in Dutch courts, the law governing jurisdiction, and the applicable law in case involving international aspects. For example, because the parties are from different countries, is not part of international law, but forms a more specialized branch of private law. The Dutch legal system in the Indonesia legal system, the law in Indonesia is inseparable from the historical context. The law in Indonesia adopts the Dutch legal system. Indonesia used the Dutch legal system because at the time, Indonesia was a Dutch colonial colony. And because at the same time, Indonesia did not yet have law originating from its own tradition. The legal system in Indonesia used the continental European system. Along with the development of the tradition and custom of the Indonesian people, Indonesia has implemented a mixed legal system between the continental European and Anglo-Saxon legal system. In addition, Indonesia also implements a legal system that is in accordance with the thoughts of philosophers with the Positivism school.